Hey, good morning, folks. Can everybody hear me? All right, I am Aaron Lieberman. We're starting a couple minutes late, but we're going to dive right into it because this is a really dense topic that we're trying to distill down into some very targeted questions. Welcome to day one of America Outdoors. Welcome to the Explore Act panel. Once again, I'm Aaron Lieberman, for those I don't know, though I do know many of you in the audience, and I'm the Executive Director of America Outdoors. Also with us today, we have John Simon. Say hello.
Everybody.
And then we have our panelists. Sadie Wehunt with the Forest Service is National Recreation Special Uses Assistant Program Manager. I'm going to go very quickly through all these introductions. If you want to know them better, please find them afterward and get a little bit more information. Sean Wetterberg, your bio only said, is the best bio. It said National Ski Area Program Manager, no other words.
Wait a second. Does that explain why my picture wasn't on there?
I got your picture on there. Kurt Roush is the chief of the National Park Service's Commercial Services Program, where he oversees concessions, commercial use authorizations, and related visitor services across the national park system. Kurt Roush. We have Kevin Oliver. Kevin Oliver is the chief of the Division of Recreation and Visitor Services with the BLM. His bio is much lengthier. So again, if you're more interested in Kevin after the panel, I'd encourage you to go find him and ask him tough questions. Not least, the man who needs no introduction whatsoever, David Brown. Everybody know David Brown? That's actually a lot fewer than I thought. David Brown, you want to give the 30-second or less introduction of yourself?
Yes, I was executive director of AO for 28 years and know most of you here. A lot of new faces. Glad to see you here. Thank you so much.
Okay. We're going to go fast through that first part. Just to help set the stage for what we're talking about, how many people, I'm guessing everyone in this room, since you're here for the panel, how many people know what the Explore Act is? Okay. How many people have read the Explore Act or Title III in the Explore Act? That tracks. To give us a little bit of a primer, this act is incredibly important. It has some really relevant provisions and some really good provisions for folks in our industry, but it is the product of decades of advocacy and multiple different iterations. To give us a very short 100,000-foot view of where this came from, Dave, would you mind speaking to where did the Explore Act come from? What problems was it trying to solve?
Well, the Explore Act actually originated when the Federal Lands Recreation Enhancement Act, which was the original authority for issuing outfitter and guide permits, expired in 2014. But it goes way back, way beyond that. And actually, all the way back to 1982 when the Forest Service, someone discovered a letter that the Forest Service had sent out saying they were going to put all outfitter and guide permits out for bid, and the industry got all upset and marched on Washington and was able to change that. But the policy, Forest Service policy, was interim policy for years. It wasn't finalized until 2004. And then the Federal Lands Recreation Enhancement Act was passed, which allowed the agencies to keep all the recreation fees, and the fees returned to the agency, but it also became the permitting authority for the Forest Service, BLM, Fish and Wildlife Service, and Bureau of Reclamation. However, there was a sunset clause in FLREA. So in 2014, it was set to expire. So in 2012, we went to the chairman of the House Natural Resources Committee and said, hey, we've got to renew this permitting authority. And so it's very vague in the original FLREA, and so we think there need to be some, a little bit broader direction to the agencies, and that's how FLREA got started. And so there were several reiterations before the Federal Lands Recreation, before the Explore Act. The GO Act, for example, we weren't really changing anything dramatically. We were tweaking a few things that we'll discuss later on in this session. But then there were also some other interest groups who were seeking access, especially the institutional users who were looking for access. So as time went by before FLRIA would be reauthorized every year, and then we were advancing the Explore Act. The Explore Act actually passed the House but never got passed by the Senate. And so the groups began to get together, actually, and we weren't always, I would say, we were somewhat competing with one another for some of the provisions in the bill, but we came together eventually in creating the Explore Act, or at least Title III of the Explore Act, which deals with the permitting authority. Now, we're not responsible for all the language in there. There are provisions in there we don't necessarily agree with, and I think probably create some unrealistic obligations for the agencies that may need adjustment down the line. But the bill did make a number of important advancements, I think, for your business, for your business survival and viability. And it standardized some of the provisions that had been in policy previously. And that's the important thing for you to know now, is that some of this is now law that was policy. For example, the use reviews are now mandated for the Forest Service. They're discretionary for BLM. So it's going to be really important for you, when you get your permit, to sit down with someone and read your permit aloud, because the permits are going to change to be consistent with Explore. There are going to be several changes like that that are going to be critical for you to understand, and we'll discuss those as part of this session. But I think that's you will see that unfold, hopefully, and part of the reason we're having this session is to try to get a sense from the agencies how the rulemaking is going to unfold with regard to Explore. But I do want to give you a thumbs up for attending this, because you're going to be way ahead of a lot of outfitters who are not paying attention. Because it's going to be vital for you to pay attention. There have been some policy changes in the past with the Forest Service where outfitters were not, certain people within the community were not paying attention, they lost their businesses. In 2008, when the Forest Service revised their permitting policy, they eliminated temporary permits for more than 200 service days, and there were a lot of people operating on temporary permits, and unless they sent a letter to the Forest Service requesting transitional priority use permit, a lot of them went out of business. So that's kind of the situation that you're potentially, not that issue, but there's some issues in the bill that are that important for you to understand, so that when you have use reviews or you have events that prevent you from using all your allocation or capacity, you know how to deal with that.
Well, and David has alluded to some of those key changes, and those are the thrust of the questions that we've asked our agency partners here to dive into in advance. But just maybe to give folks a top-level summary of those. I mean, David, you alluded to several of them. One is the changes to the use of allocation review process, right, with the mandatory 5-year review by the Forest Service and the changes to that formula itself, while BLM still remains discretionary. There's also surrendered use credits and some changes around that we have some questions on. Are there any other key highlights that you'd flag on the top level before we dive into the questions about those key changes?
Well, one of the real benefits, I think, is a provision in the bill that prohibits the agencies from developing a policy that prohibits exculpatory agreements, also known as waivers. And so that
yeah, use your mic.
Sorry.
There you go.
That was part of the law, and actually was not didn't apply to NPS contracts, but fortunately in the bill. But fortunately, NPS adopted that as well as policy later on. It also sets, for Forest Service and BLM, it also sets the permit fee at 3% of gross, which is an important thing. As you know, regardless of your politics, the federal government is under the gun financially with $36 trillion in debt, and so they're going to be looking for money under every bush. And so it's important that we still have reasonable fees to allow you to develop, to run a profitable business. And, and some people think profit's the measure to which you take advantage of the public. Well, that is wrong. Profit is what you need to buy new equipment, repair your vehicles, put a new roof on your building, reward your employees, and serve the public. So you've got to maintain profitability, and that's at least one of the values of that provision in the bill.
Thank you, sir. That is very top level, but hopefully y'all have done your homework or watched some of the webinars or information that America Outdoors has been putting out in advance and have a baseline for some of these issues already. Use of allocation review changes, surrendered use credits, exculpatory agreements, and changes to the adjusted gross revenue or flat fee structures for outfitter fees. To get right into it, because there's a lot, and hopefully we can get through the majority of these questions. I think this first question, we're going to start with sort of the category of permit terms and statutory changes. So in that first category that David spoke to, and I believe with the exception of Kurt with the MPS, this will apply to everyone on the panel here. So there are important changes, as David spoke to, that the Explorer Act made to the permitting regime, in particular for Forest Service, but for Forest Service BLM. To the extent that these changes affect actual permit terms, can you confirm that all new and reissued or renewed permits going forward will reflect these changes made in code? I'll start with you, Sadie.
All right, thanks. So basically, in consultation with OGC, the act itself is not. It's not self-enacting. It didn't go into effect just when the law passed, which you'll see deadlines in there throughout. So this does require the agency, the Forest Service in particular, BLM can do it a little bit different, but we need to actually make those changes in our handbooks and manuals, our policy, our directives, before they can go into effect. So basically, we're aiming for a timeline of, do you want me to run into this? Yeah. Of April 1st, beginning April, to where we can enact all of the what are called technical changes. And those are the changes that you'll see in the act that say pretty much the secretary shall. That requires us to make those changes without notice and comment. We don't need to go out for notice and comment. We don't need to do consultation with the tribe. Those are the items that can take quite a while. And basically, we were originally going to go out with, as a lot of you know, we've been working on a lot of these changes. A lot of them were in the act, but it required notice and comment. And basically, after the shutdown, we really decided to pivot from that because we knew that timeline was just going to be too long. So along with those changes, I'll just run through them real quick. The nominal effects determination, the needs assessments, limiting where they're required, temporary use permits, the changes to those, surrender of unused visitor days, the use of allocation review, adjustment of allocated visitor use days, the fee calculation methods, the monitoring requirements for temp use, the indemnification that one we already have in effect, sorry. Exculpatory agreements, like David talked about. And those are also what we heard from America Outdoors and other state outfitting groups were a lot of the priorities as well. So we're going to address those, get them into effect before this operating season, and try to, at that point, look at another round of updates that will require the notice and comment. And now those are places where the act says may, the secretary may, or the agency shall develop guidelines. If there's any guidelines involved or setting new standards, we have to go out for notice and comment.
It's a small button. Just to clarify, that list you just went through, those are all things that you anticipate you'll be able to have updated in the handbook in advance of this coming operating season, which I'm guessing you're thinking mostly in terms of river-based or summer recreation?
Exactly.
She said exactly, in case you missed it.
Can I just ask you a quick question?
Only through the mic. There you go. Yep.
Do you think, I guess the question for a lot of us is, you have permits that are expiring now, so some that and are going to be reissued. Are you going to hold off on doing that until that language is in the permit?
What we'll do is we will have to go through and amend all those permits. If you take a look at your existing permit, there's clauses in there that specifically now contradict what the law says. So we haven't had specific conversations with OGC, but just from our basic approach, I think that we're going to have to go through and change the, it's going to be a lot of back and forth. The permit holders now have 3 different fee options that they can choose from. So, it's going to have to require some identification of what type of fee clause we're using, and then also the reallocation of user days. Some of that needs to be cleaned up as well in the clause that's currently in the permit. So I think that we'll go ahead. Like I said, we cannot, until we update the policy, make those changes. So it'll probably just depend on where they're at with operating season. I know a lot of times they're already getting their estimated use in at that point in time. So the coordination with the local unit is going to be key.
Well, I guess what I'm asking is, for the use review, for example,
Yeah.
sometimes those use review clauses are in the permit.
Yeah.
And so if somebody gets, so now the new provision is that everyone is assigned actual use plus 25% in the highest of 5 years when your use is reviewed, or when your permit expires and it's reissued.
Mm-hmm.
But if you get my question is, and maybe it's a legal issue, but if you get a permit and you sign a permit that has the old use review plus 15% for over 1,000 service
Mm-hmm.
days, I would be reluctant to sign that permit unless, but it's really a question of what should the outfitter do in those circumstances?
Well, Jesus Christ. I'll show you all after. It's an absurdly small button. In any case, and that is a question that we have coming up, and it is a good one. I want to pass it over to Kevin, but to clarify, it's a maybe on whether or not any permits issued, say between tomorrow and the updating of the handbook, may or may not include the new
They will
terms.
not.
They will not.
They
But
will
they will
not.
still be reissued in the interim.
And
just have to
then
be updated
amended
after the
when
fact.
we publish the new directives, correct?
Yep. So everybody bookmark that because that comes back in 2 questions. But before that, Kevin, do you have a mic over here?
Yeah.
Yep.
Good to go?
All right. Yeah. Would you mind speaking to that first question?
Yeah, absolutely. If you don't mind, a couple words. First of all, since last January, we've been really digging in on the Explore Act. 82 pages of amazing legislation. My compliments to the House and Senate staffers and America Outdoors and other, AMAGA, or all the entities that worked on this, because it is, it's specific, it's detailed, it tells us what to do, tells us where and how to do it. And that complexity created a lot of questions. We've had a lot of conversations with the Forest Service and circling back with AO, circling back with AR to understand exactly what was the intent, what was meant, in order to be able to deliver on the expectations. So the BLM's taking a similar but maybe a slightly different tact. We have a different set of lawyers. Our solicitors have been working closely with us as well. So our approach is going to be, we're trying to be simple, clear, and understandable, and most importantly, provide for continuity of operations, right? That's the one thing we all understand. We need to be continue to operate. So any permits that you have that are signed and valid can and will continue under the old terms and conditions. That's an agreement, it's a contract, and that can move forward. So you have the continuity of operations there. So that's a multi-year permit that's just been revalidated for another season. It's good to go. Our intent is early February. February 2nd is the date I'm keeping in my pocket to go live with Raptor. How many people in here have been through Raptor and received a permit through Raptor? Glad to see a few. I hope next year many more will raise their hands. I'm expecting that'll be the case. Because this is so complicated, we've gone from 4 permit types to 9 permit types, and there's a lot of information to help the agency decide which type of permit that winds up being, asking you questions to make sure we understand exactly what your intent is, having conversations about, well, you might have to adjust this or that to smush it into that particular permit, if you want the permit versus the action. So there's a lot to it. So we've been working since May. We triggered our contractors to revise Raptor to reflect all the detailed permit types in and the insurance and the visitor use day reallocation, all those things in Raptor. And so we're intending to go live in early February. So what I'm saying is that the door will be open to apply for a Title III permit in early February. We have between now and February to train our staff. Right, up until this point, it's been a heavy focus between our interagency collaboration and our programming work to make sure we totally had guidance and help our staff understand what all the Title III requirements are. So it's a really heavy lift. There's a lot of people shaking in their boots, but we don't mind a little bit of fear spurs you to perform well. And so that's our intent. So I guess what I'm trying to say is that if you have an old permit, you have continuity of operations under that permit. But if you want a Title III permit and all the benefits, which we know and see and value, thank you for bringing more people to America's public lands. What you do is critical. The way to get a Title III, the benefits of Explore Act would be to apply. The only thing I would say is that we're expecting a high volume. We have 5,000 SRPs out there and only 1,300 in Raptor. And all of them are going to need to reapply if they want Title III. So I can imagine a big traffic merge, especially at the field office level that has a high volume of SRPs, of applicants and workload and workflow. So I can't say it's going to vary from location to location on how that processing will go. Our processing under Raptor went from 80 days on a paper application to 60 days. We're hoping that's going to stay down in the 60 range, but with this intense volume and all the questions that are coming up and getting back and forth, we intend to be as successful as possible. I'm not sure did I answer your question.
I think you answered the question. I have one question myself, and then I can see David itching in his boots to ask a follow-up. And I think I know what he's saying. Give me 1 second first. David, when people say Title III, do you know what they're talking about, a Title III permit? Okay, that's what I thought. So when we talk about Title III, we're talking about the SOAR Act within the Explore Act, and more specifically, we're talking about these specific provisions that David alluded to at the outset and that AO has been putting out information about, that AO advocated for, but that help streamline in general terms, right? That help streamline permit processing that otherwise provide real meaningful benefits for your operations, for permitting. So I guess maybe, and David, feel free to jump in if I'm asking the same question you were wanting to ask, but when you say Title III, that you'll have to reapply for a Title III permit, you're just describing new provisions in existing authorizations that now incorporate the requirements of Explore, right? Yes. First to you, and then that should be a short answer, I'm guessing, but then
I'm
to
hoping
David
so,
maybe.
but I've been thinking about Explore Act for the last year constantly, so I tend to go far. So what I'm saying is existing permits are good to go under existing terms and conditions. If you want any of the provisions of a Title III under Explore Act, all the good stuff that's in there, you need to reapply, get processed, go through the process, receive a signed permit to function, and like the choice of your fee choices and things like that. So that needs to go through a new processing, because this way we have our Raptor system that's walking you through the steps. We're not going to miss anything. I don't have an individual in the field that forgets a piece of the Explore Act, which is really complicated. The Raptor system is going to keep everything organized and step by step. You always know where the ball is, whether you need to do something or whether the BLM needs to do something, and which individual. Is it with the AO? Is it with the rec planner? So that's our intent. I'm not sure, did I answer your question?
I believe so, yeah.
We're not modifying existing permits. We're not hammering those.
Do you have a process in place, and this may be part of the education that you were talking about with staff, do you have a process in place for sending out notification and information to permittees regarding your desire that they reapply in order for these provisions to take effect, and which provisions they may need to speak to in that application?
We certainly do intend to have a public outreach and outreach to our networks, and I would imagine we should be able to send communication to every permittee. We don't have that mailing or communication train set up to speak to every permittee directly, but we certainly, it's not going to be a secret that Raptor's been changed over. There should be banners on Raptor and things like that.
So when you go to Raptor every morning, you'll see that banner. David, did that hit on the question that I saw you wanted to ask with your eyes?
No, I just want to make a quick comment that, especially in this time frame, if you have a Forest Service permit, generally there's language in that permit that says you have to inform the agency 6 months in advance if you want your permit renewed. And so be sure to do that. And you do it in writing, of course. But I don't know that the Forest Service has ever not issued a permit to somebody who failed to inform them, but you just don't want to take that risk. So be sure to read your permit and do that before the 6 months in advance. I'm not sure what the BLM permit says on that, but.
Okay. So related to David's question, one of the questions we had for BLM and the Forest Service was if you could talk about requirements in the process for notifying of interest in renewal or reissuance and timelines around that and around the renewal or reissuance process. Just so it's clear to everybody, because as David said, some of the timing specified in the actual permit, but we wanted to talk about that because it's not necessarily consistent.
So for all of our priority use permits, it has that clause in it that David was referring to. 6 months in advance, you must notify the authorized officer that you want to renew that permit. Also, like you said, that I've been a permit administrator for many, many years, and a lot of times I would end up reaching out to people as well and just saying, hey, your permit's expiring. Do you want to renew it? And so I think Aaron said it, read through your permit, and so that you are aware of what those particular timeframes are. Because it is a binding document that we can hold you to, but a lot of times we make an effort to work with the permit holder too.
And I apologize on behalf of the BLM. You got more of the leader than the manager for our SRP program, but I do know that our permit time frame is 180 days, but I'm not sure what the terms of an existing permit say. But essentially, pretty much our talking points here are going to be remain in frequent contact with your local office. Keep those lines of communication lubricated, but I would say check your permit to see if there's any such terms there. My deep apologies for not having that specific answer.
Great, thank you. Next. So Sadie, you referenced very briefly the temporary permit program, and one of the requirements in the Explorer Act is for BLM and Forest Service to come up with a temporary permit program within 180 days of enactment of the statute, which obviously we're past now. There are provisions in there for conversion of temporary permits to long-term permits, and we're just wondering if agencies could add anything in terms of regarding the development of those programs and the rollout and how the conversion process might work.
You bet. So this is another technical change that we're going to make come April, and we are going to align with the wording in the Act. We're going to have to. If we deviate or try to add anything more, then we're going to have to go out for public notice and comment, which will be the round 2. I can give you one example is the Act itself does not have a limitation on the number of user days. Currently in our policy, there is a 200 visitor use day. Sorry, we have different terms for those, but I think the Act calls them visitor use days, a limit. So we're going to have to determine what we can do at the present time, because we would like to increase that to at least 1,000 service days. So I don't know if it'll be, this is kind of working with OGC too to see how much flexibility we have. But if we can remove that requirement, that might be our first approach, and then follow it up with a second round of looking at limits on those visitor use days if we need to at that point. That makes sense?
Kevin?
Yeah, interestingly enough, Explore Act modified BLM's approach. Our current our now overridden regulations were that we could convert temporary permits with 1 year of satisfactory performance into long-term permits. Now the Explore Act requires 2 years of satisfactory performance, so we will, all of our permits issued after February 2nd will reflect those terms and conditions, and we'll have to have 2 years of performance.
So does that mean that BLM's temporary contracts will be 2 years, or will there be a potential for 1 year temporary contracts and you would just essentially have two consecutive
I believe we
ones
have
and
the
then face
flexibility to issue just a 1 year temporary permit if the authorized officer thinks that's the right approach, but that doesn't mean they can't get another one the next year and get that 2 year performance.
Great, thank you. So today's kind of Kurt's lucky day. So I think as I think most of you know, a lot of the SOAR Act does not apply to the Park Service, and the reason for that was that the authority for commercial use authorizations, concession contracts is not under FLRIA. It's under the Concessions Management Improvement Act. And we were all very careful as we were going through this not to interfere with that and not to create any confusion. So for that reason, a lot of this does not apply to the Park Service. So I'm going to ask Kurt a question. It's going to be pretty softball and kind of allow him to take a bow. But related to Explore Act, David mentioned earlier that there were some changes to the exculpatory clause authorizations or authorization for the agencies. And related to that, the Park Service made two very significant changes to its policies earlier this year related to liability waivers and related to insurance requirements. And just want to give Kurt this is our first gathering, big gathering since that's happened, and just wanted to give Kurt an opportunity to talk about that.
Yeah, thanks, John.
We have
been getting a lot of input from both the commercial use authorization community as well as the concession community regarding the challenges with insurance. And I can harken back to 15 years ago getting finger wagged by a certain senator with David in the room as well. So it's been a long-standing issue, but we were able to actually get ahead of the Explore Act on this, and we did two things. One of them was we had historically had a requirement that you could have, that you were prohibited from having waivers of liability or exculpatory clauses. You could have an acknowledgement of risk, but that was the extent of it. So the first thing we did, which mirrors the requirement that we do actually have in the Explore Act, but in advance, we eliminated the requirement for that prohibition around exculpatory clauses, so waivers of liability and indemnifications are now allowed. And there is a policy document that should be on our external website, although checking this morning, I noticed it had a big flag that said not available, so I have to go back and yell at some people to make sure that that is up for you publicly. It's on our internal site, but I didn't see it on our external site. So that was one thing we did, which hopefully will be beneficial to all of you and is a recognition for. Thanks. I mean, we do appreciate the thoughtful input that we received, not only from this community, but also from other organizations like the National Park Hospitality Association that worked really hard to give us some input. Which gets to the second thing that we did, which was also we had some provision regarding deductibles that were fairly low, and we got a lot of input that those deductibles were creating a big hardship in terms of premium costs. And so WASI eliminated the minimum deductible requirement. And so with an assumption that your insurers are going to be doing the due diligence necessary to assure that the deductible amount is reasonable for the particular policy that you're getting. So self-insured retentions and deductibles was a second policy change. Both came out in around February of last year, also available on our website that talks to that. Getting back to the exculpatory clauses piece, I will say that that was immediately adopted into our online CUA program. And so you shouldn't be seeing it there. And in concession contracts, the direction was that anybody that had a concession contract, you were supposed to have received a notification that you could immediately change over that. If you haven't seen that or you're getting some pushback from your park, feel free to send me an email, let John or Aaron know, and we can make sure that we're getting that resolved for you.
Thank you, Kurt. David.
Yeah, one quick comment on that is that the provision in Explorer does prohibit waivers of gross negligence. So if you want to get your exculpatory agreement approved, just make sure your attorney doesn't construct it in such a way that it implies that you're waiving gross negligence.
Yeah, and I think that is a condition in our policy, too, that it did not waive gross negligence. And that is a really good point, too. Make sure that you're utilizing an attorney to do this. It's a complicated document, and it is not something that you could probably do off the seat of your pants. So,
Yeah, and based on discussions with Kurt, I know the Park Service considered doing a template letter, and after some deliberation and consideration of the fact that different states have different requirements on these things, the decision was made not to do that.
correct.
Next question, and I think we'll try to power through some of this, and this one might be a quick one. But there's a lot of different levels at which the various requirements of the Explorer Act can be dealt with and need to be dealt with. Some of them are specifically required to be done by regulation. There are some that can be done by policy guidance. There are some that will be reflected in actual permit terms. And I think you probably covered all this already. I don't know so we can probably pass through this one.
Maybe
Unless-
I could just mention one thing.
Go ahead, Kurt.
We're not covered under the Explorer Act in most cases, but we actually don't have a regulation currently for commercial use authorizations. This was something that was on the table, and we had expressed interest in making sure that we were getting public comment from the community when that did occur. In this administrative priority scheme, commercial use authorization regulations are not really on the remove 10 to get one priority scheme, and so we're likely to just continue as we currently are, relying upon our statute and then a robust set of policy documents to kind of manage the program. So I just wanted to mention, you probably won't see that this year. I'd be really surprised if it came up.
And are you on question B or A?
Well, I think we sort of inadvertently hit on this question earlier.
Okay.
Maybe just to, for my own sake, honestly, just to provide a little bit of clarity. Sadie, you ran through the list of those areas within Title III SOAR of the Explorer Act that you anticipate will be developed through guidance and just implemented into the handbook in advance of the summer, spring season, something like that. What are the core areas from your perspective, just quick list, that will require negotiated rulemaking? Just to refresh me.
As far as public notice and comment?
Yes.
Yeah. So as you work your way through there, it's anything that is not specifically lined out as required in the act will require notice and comment. So you'll see sections. There's different numbered sections, and we can implement parts of it and pieces of it in this initial round, but some of it is going to have to wait until we can go out for notice and comment. So like I said, we're trying to hit those priority areas. Fees are a big one. The reallocations are a big one. So that's good news. We felt pretty good about that going forward.
And then for BLM, it's any place where our existing regulations have been overridden by the law. So there's a lot of places where the regs are just not in alignment, need to be fixed. And there's a few places where we don't have regulations to enumerate the Explorer Act requirements if we think they're necessary. If the Explorer Act is clear enough, we're good to go. But if we feel like there's a lack of clarity, that's what regulations can do. And our timeline is this year. We certainly intend to begin the rulemaking process this year. I don't have a date yet, but we have proposed it up through the chain of command to the department. They're aware of it, and I believe very high in the Secretary's office, they're paying attention to this intent and need for rulemaking.
And just really briefly, Kevin, while I still have you, BLM is not required under Explorer to conduct use of allocation reviews every 5 years as the Forest Service is within the Act itself. Do you have any, well, can you say with any, can you say categorically whether the BLM intends to or to hold to that schedule similarly to the Forest Service, or whether you've had any internal clarity on that front?
Take that. So I think our main intent is that we get the message, we got the memo. A maximum alignment between our agencies is what the intent was. You know, just full disclosure, I think we did politely ask if we could get a Park Service exemption on the Explorer Act. We're like, yeah, that's not happening. So maximum alignment, we got it. And so we do intend to conduct those 5-year reviews. But I would say that there's quite a number of BLM permits that don't have visitor use allocations. I don't know if that's the case. I think the Forest Service, everything has a, yeah, so we're different in that way. And many of our permits don't have a visitor use allocation, and we're not intending to implement them where they're not existent or what not seemingly required or necessary.
And David, I saw you raising your finger over there. Anything you want to add real quickly?
Yeah, and Sadie, I wanted to direct this to the Forest Service. There's and of course BLM too, but there is it deals with this issue of, going to the register, doing regulations versus kind of a policy. But there is a requirement in the Explorer Act that says you shall not require insurance for low-risk activities, which seems like it's very problematic in the sense is how do you define a low-risk activity? And but it says you shall do it, and I'm just wondering how you anticipate. I've got an idea for you, but
Love to hear it. Actually, we do have this existing in our current. What's it in? I think it's in 2710 with our insurance directives, that it is at the discretion of the authorized officer if the activity is low enough risk that they do not have to require insurance as it is right now. So that is one of the things that we take into account, as well as the risk when we're looking at a nominal effects determination as well. You'll see that pop up.
And BLM, similarly, as we get our staff trained up and in our internal guidance, we have some sideboards to help our field offices understand and define. We're open to your ideas because we're still writing as we speak.
Yeah.
But we do have guidance on low risk.
front country activities are low risk.
Right.
All front country?
Well, not all of them, but if you have access to emergency medical assistance and ambulances or something.
Well, I guess one of the things, again, the authorized officer is going to be making this decision on behalf of the Bureau of Land Management. And so I think, on the face of it, if you can close your eyes and pass that red face test, that, it's not a moderate or high risk event. There's probably a gray area there that's hard to pick, but there's some things that are clearly, low risk, and this makes a lot of sense. So the more documentation you can have on risk, the better.
Yeah, that's the problem. How do you define low risk? Because it almost seems like you have to come up with a definition of that.
We have some rough guidelines and definitions.
Okay, that's the question really I was asking. So.
Okay.
Maybe you guys should define
I was-
that in the act when you do these revisions. That would be helpful and
I was going to
provide
say
for
that sounds like an
consistency.
opportunity for
Yeah.
AO to provide additional clarity. Okay, moving on because there's still more to cover here, certainly. How many people got any of the, whether information that AO put out or else the webinar recently about use of allocation reviews and surrendered use? If you did, raise your hand. Okay, so a good number. I just want to get a sense for how much background we might need on it, and I'm, by nature, not good at brevity. So feel free to kick me or stop me, John. But in short, one of the core things that that the SOAR Act within Explorer provides for is to maintain use credits for surrendered use with requests for determination by the agency in advance for both events within an operator's control and outside of an operator's control. That may not be the exact language, but that's sort of the operative distinction, within or without of your control. If it is something, you could receive half credit for something that, for events within your control, full use credit for something outside of your control, pending agency determination upon request. That might not have clarified anything for folks who had not spent some time with this before. However, the next set of questions do bear on this particular area. So, where would an operator go to better understand, or to understand in the first place, the new process when that is rolled out, ostensibly in spring on the Forest Service side, right? And in February, potentially with BLM, where would an operator go in order to understand what this process is in both cases, for surrendered use and use of allocation reviews?
So probably a couple different places. The Act itself really goes into great detail. So we're going to use a lot of that language to put it in policy. So Forest Service Handbook 2709 14.14 Chapter 50 is where that will be. And it will likely be a clause in the permit too. I know that we've got a clause that talks about reallocation and that kind of thing. And then also, just to kind of jump on the extraordinary circumstances, that actually we've addressed presently in that same handbook, Chapter 50 of 2709-14. And we've been implementing it. Haven't heard any feedback that it's not working. So I foresee that we'll go ahead and continue to leave it to the discretion of the authorized officer.
Just to clarify for folks, when you're referencing extraordinary circumstances, you're speaking to these things that are outside of an operator's control, for which, like, let's say, flooding or wildfire, other things, and I don't have that list off the top of my head from that particular section of the handbook.
Exactly.
You might, it sounds like.
Yeah,
off the top
I
of
can
your head,
read it right here, yeah.
But you're just, at this point, would you say it is the agency's intention to transfer that existing definition from the handbook over in, or just to maintain
We'll
that
maintain
and point
it.
back to it in any new clause in a permit to define what extraordinary circumstances means when an operator wants to apply for full use credit for something outside of their control?
Right.
That makes sense? Not a lot of nods. John, any way to clarify that better? Nope. Okay.
Do you want me to read real quick? This might make more
Really
sense.
quick, yes.
Okay. The authorized officer may consider extraordinary circumstances that prevent a season of operation and adjust the review period to include a previous or additional year of use. For example, an administrative closure due to a fire. Hopefully that helped a little bit.
And then just quick for the BLM, it's communication and documentation, right? So I think our guidance, internal guidance, and then we'll have a set of FAQs up by February 2nd as well, so that a lot of your permitting questions under the Explorer Act can be answered by self-reading. So hopefully you don't get a whole lot of "you should have read the document" or "please read the document," because that answer's in there. But this will be addressed in that FAQ. But documentation of the event and then communication of the requests.
So it sounds like within both agencies, to whatever degree, formal direction is to maintain existing flexibility for the line officer to adjudicate the degree to which it aligns with your existing policies in the respective documents or permits.
I can't address existing policies. I've been working on new policies. So maybe they can help me out, but I apologize.
Correct.
I think this still answers the question, right? We intend to honor that ability.
Okay. David?
Yeah, just quick question on that. In those circumstances, it would apply to the entire resource rather than to an individual operation.
To all of the permit holders?
Yeah.
Yes.
Yeah, like an individual outfitter couldn't say, well, but it's possible that a fire could have affected like one guest ranch and not the entire forest, for example. So they would still be eligible for it in those circumstances, right?
Well, it depend like it depending on the scope of whatever natural disaster or event has occurred, and how many. Yeah, if it affects those operations, then and a lot of it's going to have to be kind of fleshed out too. Depending on where you offered alternatives or that's why we kind of left it up to because we deal with this all the time in the backcountry. Anyone who's got a backcountry permit in those fires, we're always looking to work with the permit holder to provide opportunities in areas that might work for them as an alternative to just saying, no, this is closed, you're done.
Maybe to flesh out what that portion of the conversation contained just a little bit. So there's two different areas. There's the use of allocation reviews and the changes to the formulas, right? And the core thing there is that now on the Forest Services end, which it sounds like the BLM correctly interpreting the intent of statute says like, hey, we're going to align with these guys, same team. Not same team, maybe, I'm not sure. Not the point. Point is that formula changes to the highest of the last 5 with a mandatory use review on the Forest Services side for 125% of that highest year. That part makes sense so far? That's an important change. And there's a number of important things you should do based on that. The other category of things we're talking about within this area has to do with surrendered use credit. And there's surrendered use credit and 2 different forks in that road. One is partial use credit or half use credit, which is not a guarantee. You don't just automatically get this. So like if I drop 15 rafts off the back of my trailer because I didn't strap them down, like that might not make me eligible if I say, hey, I'm surrendering this use early, it would be up to the line officer to determine whether or not I would still receive that. But that is something within my control, right? If it's a catastrophic forest fire, whatever else that comes through and blocks the resource, there's a administrative closure, whatever else, then I may apply for a determination of full use credit, which means that upon my next 5-year review, I would not be penalized in that instance for non-use if there were a positive or affirmative agency determination based on that request. I hope that clarified it a little bit, but just to clarify Dave's example, if there's a fire at the guest ranch, and I'm guessing where your hesitation was is, well, like, did they light the fire, right? Like, or was this a natural event? Because that would influence whether this was something under the operator's control, which is why it comes down to that line officer discretion. Is that fair? Okay. And
for the record, we are the same team at the highest level, right? So.
Good answer.
One quick thing, the voluntary surrender of use for the half-day credit, and Sadie, correct me if I'm wrong on this, but it would generally have to be done
Prior to.
far enough in advance for them to redistribute that use.
Yeah, that could be. That's the intent.
That's the
I'm
intent
sure. So,
is
yeah.
that you surrender use that you don't anticipate using, and then the Forest Service might put it into a pool that will be available for other prospective permittees or other
Exactly.
your competitors, or even you, actually, I presume.
Yes.
That is a
So it would
great
have to be
segue,
done far enough in
David.
advance, so you'll have to know what that cutoff date is.
That is a great segue to the next question. Thank you. You set that up perfectly. So will the surrender of use process still allow for an operator to surrender that use and obtain full credit under circumstances in which they weren't able to do this in advance? They may not have much notice, right? Like what are the intent? No, it will not.
Like an extraordinary circumstance.
Yes.
Then correct. I mean, we're not going to know extraordinary circumstances up front in order to, make those days available. So those will be standalone from the surrendered use days.
And that'll be a common sense thing rather than clarified in formal policy?
Yeah.
I just want to clarify that real quick. So would that mean that you would get full use credit for that then, in that situation?
If an extraordinary
Right, yes.
circumstance and the authorized officer approves
Okay,
it, yes.
Great, thank you.
And I'm guessing you'd still have to request that determination on an individual level, even if it
Correct.
was a resource-wide incident.
Generally, we say request everything in writing to your authorized
Another
officer.
reason to spend time with this.
Yeah,
Go ahead,
100%.
Kevin.
We definitely want,
Yeah.
it's about the communication and the documentation. Put it in writing, send us the doc, explain why that credit appears to be appropriate.
Thanks. So just for quick clarification, so if surrendered use would be temporary, and then the following year you would get that use back in your allocation, correct? Okay, that's what I thought.
It's kind of important because I run into it all the time. So when we get to the definition of disaster, the two things that seem to be affecting the West the most is not the direct fire, but smoke from a fire, and also low water usage. So in both instances, you can't really anticipate what's happening. Your use is going to fall, especially in the patronage, because when people know there's smoke, they stop coming. So in both of those instances, you know you're going to have use that you would like to get credit for. So what do you think the interpretation is going to be?
Similar to what Kevin just said, the process of documenting it and then and providing justification to your authorized officer. And if you're seeing a lot of inconsistencies, we definitely want to hear about it at a national level, because that's why we have policy, is to make sure that we are being consistent. But it's a fine line between providing consistency and then leaving the local units up to the decision making that happens. And everything isn't exactly the same too. So in a lot of circumstances, it's in everybody's best interest to allow that local line officer to make those local decisions.
Great, thanks. So we're running short on time now, so we're just going to kind of wrap up with, I think, two more questions. The first one for BLM and Forest Service, and then wrap it up with Kurt. I'm sure Kurt knows what I'm going to ask about, but so the fee provisions in the Explorer Act are, I think it's fair to say, somewhat complicated. There are a number of different options. Some ability of the operators to actually elect certain methodologies and fee processes, including for which adjusted gross receipts calculation you use. So it's pretty complicated, but generally speaking, there are three potential options for how your fee might be determined. One is as a predetermined fee by the agency. Another is through a calculation of what could be up to 3% of adjusted gross receipts. And then the third one is there's some authority for the agencies to impose what's called a minimum annual fee, although the statute's pretty vague on what that is and how that would be used. Can you talk just very briefly, because we are short on time, about what your thoughts are on the use of the minimum annual fee authority and then development of predetermined fees and where the agencies might be going on that?
So we actually have a minimum fee in place right now. Every 3 years, the BLM takes the lead on adjusting it according to the index factors. And actually, this year is our third year. So we need to take into account calendar year Q4. So it generally doesn't come out until end of February, beginning of March, that first quarter. So we don't have any intent to deviate from what we are currently doing. Both the assigned site fees and the minimum fee for outfitting guiding are affected by that.
Thanks.
Yep, and BLM's minimum fee is $7 per day per person, and I believe that gets implemented as a floor. So if any of the other calculations are intended to be selected, and they calculate at less than that, I believe the minimum fee is the floor. Is that? Yep. So that's how it would be implemented.
Yeah, if the fee determination method comes in below that, right, then it defaults to that minimum fee.
Okay. So, I don't know if David wants to ask a question. Oh, okay, yeah. Just in the interest of time, I know there are more questions on fees, and we can address those later. But last question for Kurt. So I think some folks heard me talk about this yesterday. Last week, the Department of the Interior announced in response to an executive order that the president had issued back in July that there will be, starting January 1, 2026, a hike in fees on non-residents. See, I can use the terminology, Kurt. So that includes a higher annual pass fee from $80 to $250. And then also on top of the existing entrance fee in parks that, in 11 parks that charge them, and it's really the 11 most visited parks, there's an additional fee per non-resident age 16 and over of $100 per person. There are definitely some questions that I know you've heard from other groups and that folks in this room and this industry certainly have as well. And so, Kurt, I know that you're just learning about this as it's all coming out too, but wondering if you could talk just a little bit about that and what folks could expect and how we raise any concerns that folks may have about it.
Yeah, so we're kind of building it as we go, so I don't have a lot that I can offer in terms of any more detail than what communications have already been put out by the National Park Service. I actually was on a call just before this that included the acting director, and there was information that we intend to have some Q&As hopefully by the end of the week or early next week that should provide additional clarification on the host of questions we're getting. I would strongly encourage, if individuals have concerns, questions that they impact information, that you provide that. You can send it to me. You can send it to Jessica Bowen, or who is the comptroller exercising the delegated authority of the director, or the secretary's office, to give them input on the concerns that you have. We're certainly getting a lot of that information in. Operationally, we are still working through how this will all occur in terms of the process for getting the $250 non-resident fee in advance, which will be available through rec.gov starting January 1st, or assessing the surcharges at the gate, which will occur for those individuals that don't have the $250 annual pass. So there's a lot that goes into that, and I don't really have a lot of answers yet, but that's essentially what's happening. So look forward to, and we're most interested in just getting your questions and concerns so that we understand the landscape. As Jessica indicated, our interest is making sure that this is as seamless as possible come January 1st. And at this point in time, January 1st is what's happening, and we have no reason to think that that's going to alter.
Great, thanks, Kurt. And AO will be happy to collect those questions. So if folks in the room do have feedback, questions, concerns, definitely let Aaron and Karen and us know.
Okay, that was a lot really fast. And nope, sorry. That was a lot. We're already 4 minutes over. I love you.
Now, I'm going to say something. Anyway. I want to tell you something, guys. The special use permitting program in these agencies is one of the most successful things in the government. And it is unheralded and unrecognized. And of course, these people up here are part of that. And part of the reason it is so good, but it's done so well, and because of you and the quality of your services. But someday I hope we find a way that folks will recognize the value. And really it's so much criticism of some federal programs. This is one that has really worked well.
Okay, that was totally worth it. That was totally worth it. Yeah, I also was going to just extend a thank you for being here. That actually is some new information and really helpful information. And we really appreciate all the time and energy you've put into this. I know it's thankless.
You bet.
Including from us.
We're happy to stick around too, and we'll be here, so feel free to approach us.
Law of verbal traps, you heard her. Also, thank you all for being here. I know this is complicated stuff. Feel free to call me. Feel free, and also just look out in upcoming communications. We're putting out more information about this stuff, watching webinar 2 or 3 times. We'll have 3 more of those coming out in the next couple months, diving deeper into different provisions within Explorer so we can spend a little bit more time with things. You can ask more questions. Thanks for being here. We'll see you in the next one.